Hi, I'm Dennis Cuevas, Director of the CLE program at the DC Bar. We hope you're enjoying this virtual conference marking the 100th anniversary of the 19th Amendment. This session, Understanding Economic Damages in Intellectual Property Disputes, is eligible for CLE credit in all states that have continuing legal education requirements. An alphanumeric code will be read out loud and displayed sometime during the presentation. Please take the time to write down the code. Within the next 24 hours, those of you who have registered and paid for CLE credit will receive an email with a link where you will then identify the correct codes to receive credit. As we enter our busy season with many state CLE deadlines fast approaching, please allow up to 30 days to process your certificate of completion. Also in that same email, there will be an electronic evaluation form. Please take the time to complete the evaluation. We need a significant number of them back for accreditation purposes, but more importantly, we review them carefully as we always look for ways to improve our classes. If you have any questions about obtaining CLE credit, please send an email to cle@dcbar.org and we will be happy to assist you. If you're watching this pre-recorded program during the live broadcast, please feel free to pose any questions you have in the chat room since our presenters will be available to answer questions that you have. Now, without further delay, let me turn it over to our distinguished speakers and enjoy the program.
Thank you, Dennis, for those announcements. Hi, everyone. My name is Kevin Chu, and I'm the moderator for today's discussion. I'm an intellectual property litigator at Quinn Emanuel Urquhart & Sullivan in Washington, D.C., and we're here today to talk about economic damages in IP disputes, with a particular emphasis on patent disputes. Now, as anyone who's followed or litigated a patent dispute in a district court likely knows, damages is typically one of the cornerstones of the case. And generally speaking, when a patent owner sues someone else for infringing their patent, the patent owner is seeking either monetary damages or an injunction, or perhaps both. Now, to show whether monetary damages make sense and the amount of monetary damages that the plaintiff should be awarded, parties often hire economists to help develop their damages contentions and to prove that their contentions, methodologies, and calculations are correct. Speaking of economists, today we have two very special guests here in David Kaplan and Jeffrey Klenk. Mr. Kaplan and Mr. Klenk are both economic experts who have done significant work in patent disputes and achieved great results for their clients. Starting with Mr. Kaplan, he's the executive director, vice chairman, and a member of the board of managers at Berkeley Research Group. He's incredibly experienced as an economic expert, having testified on numerous occasions in both federal and state courts, before arbitration panels, before regulatory agencies, and even before Congress. Mr. Klenk is a director at Berkeley Research Group and, like Mr. Kaplan, has extensive experience as an expert economist in IP disputes. He's offered expert analysis in both district courts and before the Equal Employment Opportunity Commission. He's also done significant work analyzing both economic domestic industry and public interest issues in Section 337 investigations before the International Trade Commission. And with that, I will turn the floor over to Mr. Kaplan and Mr. Klenk.
Thank you very much, Kevin. Both Jeff and I and Kevin today are going to spend a little bit of time discussing concepts and principles focused on the issue of the calculation and analysis of damages in intellectual property disputes. We're going to focus our discussion on the analysis and calculation of damages that relate to patent disputes, but much of what we're going to discuss today would also be relevant in other intellectual property matters, such as trade secrets, by way of example. Before we get into the substance and structure of a conversation about different principles and analysis relevant to patent damages, I do want to point out that what we're going to discuss today is general and informative and relevant. But of course, any damage analysis needs to be conducted within the construct of the particular facts that are relevant to any particular matter. And I want to emphasize that because each matter may bring idiosyncratic issues that would bear on some of the general concepts that we're going to discuss today.
Thank you, David. Whenever I sit down to talk to attorneys about matters of economic damages, I always like to do a basic primer on what the general idea of economic damages means, or what the purpose of economic damages is. And so I like to start off with this idea of economic injury. And as an economist, I think of individuals or firms having a particular economic position. And that an economic injury is what results when there is some wrongful act, here patent infringement, but any wrongful act that for some reason may diminish the plaintiff's economic position. So you could think about a corporation losing sales and as a result losing profits. You could think of an individual losing earnings either through a wrongful termination or a wrongful death. And so a party has suffered economic injury if it can show that its diminishment in its economic position is specifically attributable to a wrongful act. So oftentimes, as an economist, when I analyze a fact pattern, there does appear to be some sort of diminishment in a plaintiff's economic position, but it isn't always related to the wrongful act being alleged. And so one of my primary jobs as an economist is to investigate the causal link, or to investigate the reason why economic diminishment or diminishment in some sort of economic position came about. And that is something that David and I and Kevin will keep on returning to throughout our presentation, and particularly in the context of intellectual property damages. What are some economic issues that need to be investigated to demonstrate a causal link between the patent infringement and the diminishment in the plaintiff's economic position?
As Jeff mentioned, the focus here is on economic damages in intellectual property matters, and particularly in patent matters. And as Jeff articulated, the focus here is to restore the plaintiff to the economic position or financial position it would have occupied but for the alleged wrongful conduct. In certain situations, there may be certain legal restrictions with respect to this general concept. But as an economist, what we're focused on is if a individual or firm suffered some form of economic damages, the process by which we measure them is focused on restoring that allegedly injured party back to the same financial position it would have maintained but for the conduct at issue. It is critically important, as Jeff articulated, however, that damage be directly linked to the conduct at issue and not caused, for example, by conduct unrelated to the issue. It is very important to isolate the alleged damages specifically to the conduct at issue. And of course, the premise here of economic damage that we're articulating is not only relevant in patent damages, trade secret damages, but this general concept is also relevant in other areas such as antitrust, breach of contract, and employment.
And so for those of you who may have been involved in a damages analysis before, you may have heard the phrase "but for world" or "but for the wrongful conduct." And so as economists, what David and I try to do is recreate what economic position would have existed but for the wrongful act. So our job is to remove the economic effect of the wrongful act that happened. And then that is a recreation to the best we are capable of the but-for world. And then once David and I have recreated the but-for world, we compare the plaintiff's economic position in that but-for world to the plaintiff's economic position in the actual world. And as that term suggests, it is the world that actually happened. It is the world in which the alleged wrongful conduct or the bad act happened. And so then it is a comparison of economic positions. On the one hand, it's the economic position in which the bad act didn't happen. And on the other hand, it's the economic position in which the bad act did happen. Now, oftentimes, that entire difference between the but-for and actual worlds is not attributable to the wrongful conduct. Oftentimes, there are other intervening factors that may have served to decrease a plaintiff's economic position. And here again, as economists, as David just said, it is our responsibility to isolate this specific diminishment in economic position attributable to the wrongful act. And as economists, David and I have a number of tools available to do so, and we will discuss some of those tools throughout the presentation. So simply a comparison of but-for and actual worlds oftentimes won't be sufficient. Oftentimes, David and I have to go one step further and really isolate the difference in economic position that can be linked back to some sort of wrongful act. So as David noted earlier, our presentation is primarily going to be focused on economic damages stemming from alleged patent infringement. However, many of the techniques that we're discussing today, particularly this idea of a but-for and actual world, can be used in just about any sort of damages analysis. And many of these specific techniques we're going to be discussing, such as the negotiation of a reasonable royalty, have relevance for any number of intellectual property disputes, such as disputes involving trade secrets.
Now, Jeff, in your experience, are there is there different analyses you do depending on what type of case it is as an economist, between like a trade secret case or a patent case?
Yes, that is certainly the case, and particularly when you get into trade secret law. And I want to be careful here, since I'm an economist and not an attorney. I understand that damages in trade secrets are oftentimes governed by state statute. And so oftentimes you need to be, if the trade secret case is being brought in state court, you need to be aware of the remedies specifically available to you in that state. But for instance, my understanding is that many states permit reasonable royalty damages to be collected on a trade secret misappropriation. And so the idea of a hypothetical negotiation, or modeling a hypothetical negotiation, as we'll get into in a few minutes, could be used in either a patent infringement case or a trade secret case. And then just one thing that's important to note, and as I started answering Kevin's question here, David and I are economists. We are not attorneys, and we are not technical experts. And so David and I aren't in a position to render an opinion, nor would we be ever asked to render an opinion on whether a patent is truly valid and truly infringed by the defendant. So David and I, regardless of whether we are working for the plaintiffs or the defendants, always assume that the patent is both valid and infringed. Now, for those of you who practice in the intellectual property space, you realize that that assumption oftentimes doesn't hold true, that there are legitimate questions as to whether the patent being litigated truly is valid, and whether the technology at issue truly does infringe that patent. But for the purposes of damages, David and I simply assume that both of those conditions are met.
So today we're going to focus, as we discussed, on the concept of damage calculation in patent infringement cases. And there are two general cohorts that are relevant in thinking analytically and structurally about how one might approach the issue of analyzing damages. One is lost profits, and lost profits arise where a plaintiff can show reliably that it would have made additional sales, but for the defendant's infringement. Lost profits obviously arise in situations where firms are competitors, for example, and would not be relevant generally in situations where the patent holder is not actually in the business of producing a product that makes use of the technology. The second area that is relevant in analyzing damages in patent cases, in addition to lost profits, is the concept of a reasonable royalty. And that involves a negotiation between the parties, as Jeff mentioned, in a hypothetical world in which one assumes that the patent is both valid and infringed. Let me talk now briefly about the concept of lost profits and the criteria used to analyze lost profits in a patent case are generally governed by a lawsuit called Panduit and the so-called 4 Panduit factors. And those factors include that there is, in fact, demand for the patented product. Obviously, if the patent holder is claiming that it lost sales as a result of the alleged infringement, then there must be, by necessity, demand for the product that provides the foundation for sales that would have existed. In addition to that, the Panduit also talks about the absence of an acceptable non-infringing alternative. And here the concept is that in order to demonstrate reliably that the patent holder would have lost profits, if there are many other products that are not infringing that competed with the product at issue, then there is more unreliability and uncertainty associated with the position that the plaintiff is taking that it would have made the sales in the but-for world. And so the Panduit focuses on the absence of acceptable non-infringing alternatives as a focus of reducing that level of uncertainty and providing more confidence to the researcher that the patent holder would have made sales but for the alleged infringement. Third, not surprisingly, if a plaintiff is going to advance an argument that it would have made additional sales, it has to demonstrate that it had both the manufacturing and marketing capability to exploit the existing demand. As economists, we sometimes refer to this as economies of scale, focused on manufacturing and production, and economies of scope, focusing on the issue of marketing. Finally, if a plaintiff is able to demonstrate reliably that it lost sales, it then has to turn those lost sales into lost profits. And the focus here is on estimating what the incremental profits would have been on those incremental sales that would have existed but for the alleged infringement. And I emphasize the word incremental because in patent matters, it is not unusual for there to be a substantial difference of opinion between the parties as to what costs would have been incurred by the plaintiff in making the incremental sales. So, for example, if sales had gone from 10 to 11, the patent holder might argue that very few costs would change. For example, the size of their factory might not change. They wouldn't need any new equipment, and other so-called fixed costs would not change, and therefore should not be deducted from sales in estimating lost profits. On the other hand, if there are a substantial change in the sales estimated by the plaintiff that it would have made but for the alleged infringement, it's possible that more costs could be deemed incremental and have an effect on the profitability. And this concept of incremental profit is in many instances an area of substantial dispute between the parties and involves meaningful and significant analysis of cost records of the patent holder. In fact, could involve some form of statistical analysis, such as a regression analysis focused on trying to study the relationship between changes in sales and changes in costs to try to understand which costs change as sales are altered, or something called an activity analysis, which is a more straightforward focus on looking at the production facilities of the patent holder and trying to understand which of those costs associated with that production would actually be altered depending on the estimate of lost sales associated with the alleged infringement. And these are the so-called 4 conduit factors that a researcher would analyze in trying to conduct an analysis of lost profits.
And so after with that overview in hand, I will go into some of the conduit factors in a little bit more detail. So as David noted, the first of the 4 so-called conduit factors is demand for the patented product. And so it may be the case that a patent holder loses sales to a competitor selling an infringing product, but that is not dispositive that sale was lost to the competitor as a result of the patent infringement. That there may have been features of that product that were not infringing that in fact drove consumers to purchase the product from a competitor rather than from the patent holder itself. And so, a common example here is simply on the basis of price. It may be that a competitor made additional sales at the patent holder's expense simply because it charged a lower price, not because it was illegally using the patent holder's technology. Or you could think of a multifaceted product and it was on the basis of some other feature not subject to the patent that drove sales from the patent holder to the competitor. And so oftentimes what David and I see in patent infringement cases where a plaintiff is advancing a claim for lost profits is a fairly cursory showing of a high level of sales. That oftentimes we'll see an expert say, look at the volume of sales made by the defendant. This is assumed to be an infringing product. That is indicative of demand for the patented product. Well, that could be indicative of demand for the patented product, but as I just noted, that's not necessarily dispositive. And so oftentimes in our experience, it is necessary to go beyond just showing a high level of sales for a patented product that was sold by a competitor, but actually digging into what was the basis for those sales, and was the driver of those sales the patented technology itself versus some other feature or some other price point. The second of the so-called conduit factors, as David explained, was the existence of non-infringing alternatives. And so here it is the responsibility of an economist to analyze the possible substitutes in the market. So to analyze other products that generally have the same functionality as the infringing product and generally are sold at an equivalent price point. So if a product is priced radically differently, David and I as economists may come to the conclusion that they aren't in fact substitutes. Or even if 2 products are priced similarly but have very different features, then they may not be substitutes either. And so as economists, David and I routinely wrestle with the idea of what products are substitutes for one another. David and I both do a lot of antitrust work. And so we might bring in some of the same techniques or methods that we use in the antitrust space to analyze the idea of substitutability here. Now, as David said, the existence of non-infringing alternatives doesn't mean that lost profits are necessarily off the table. The issue is that when there are a number of non-infringing alternatives, it introduces some uncertainty into this process. That no longer is it the case that the infringer or the defendant necessarily was the one making the sales at the plaintiff's expense. So if you think about a market with only 2 competitors, that market in many instances is a zero-sum game, that when one of the sellers makes a sale, it's at the direct expense of another seller. But as you start increasing the number of sellers in the market, then it's not clear, if you were to remove one of those sellers, who necessarily would have made the additional sale. Sometimes it's possible to adopt an analysis that has become known in the patent space as a Moore-flow analysis. And Moore-flow is just a reference to the case from which this analysis is coming. And it is simply a shorthand way of referring to some sort of market share apportionment. That if you were to remove the infringer's sales from the marketplace, then the Moore-flow analysis would suggest that the plaintiff would have made those sales based on the infringer's share of the market. So if the infringer, say, comprised 25% of the market, then it might be possible to attribute that share of sales to the plaintiff. Obviously, this is a fairly simplifying assumption, and one would need to analyze a host of other factors to understand if that assumption makes sense. But there would be a basis for undertaking some sort of market share analysis in the presence of a number of non-infringing alternatives.
As I mentioned before, in addition to dealing with this issue of demand and non-infringing substitutes, the analysis also must involve facts and other relevant material that would allow one to reliably determine that the patent holder had the manufacturing and marketing capacity to make the sales that are relevant. One of the issues involved in that situation is the magnitude of the lost sales. And previously, I mentioned a situation where hypothetically, in the actual world, the sales were 10, and in the but-for world, the plaintiff is arguing that the sales would be 11. That's a relatively small change, again, depending on the facts of a given situation. But a fact pattern might be more susceptible to proof on the issue of what we call economies of scale and scope, i.e. manufacturing and marketing, if that sales change is relatively small compared to the actual sales being made by the patent holder in the actual or real world. And you might imagine the opposite, which is if the incremental sales change is estimated to be very substantial, by way of example, 2 times or 3 times the size of the sales made by the plaintiff, then one might be more incredulous to the argument that the plaintiff had sufficient capacity, both in terms of manufacturing and capacity. Having said that, these simple examples I provided are no substitute whatsoever for a detailed investigation of the capacity at the manufacturing and marketing level of any given patent holder to reach this determination. The incremental sales estimate might be small, and still one would conclude that the patent holder did not have sufficient capacity to make the sales. The incremental sales change could be estimated to be very large, but a rigorous and meaningful investigation may well determine that the patent holder had the capability of making those sales. And just by way of example, if you had a patent holder whose sales had doubled over a period of, say, 2 or 3 years, and the incremental sales estimate in the but-for world, i.e. but for the alleged infringement, is a doubling of sales over 2 or 3 years, the fact that the plaintiff had achieved that in the real world prior to the infringement obviously would be a relevant consideration in reaching a judgment about this particular fact. Again, each fact pattern is going to be different, and one has to engage in a rigorous investigation of that issue. And let me also add one other point about the non-infringing substitutes before we leave the Pandua factors. Jeff mentioned the concept of intersection between, at an analytical level, patent analysis of non-infringing substitutes and antitrust. In antitrust, there is a toolkit that economists use in analyzing market definition, i.e., do products compete? And in that toolkit, you might find statistical analysis, such as regression analysis, or other sophisticated ways to analyze whether products compete. And products can compete even if their prices are meaningfully different, if small changes in prices of one product would cause substantial changes in the demand for another product. And so here there are more tools to the economist that are relevant. And those tools are not only relevant in the non-infringing capacity, they're relevant here in the marketing and manufacturing arena. But finally, the fourth can-do-it factor is this incremental profit issue. And as I mentioned before, with respect to incremental profit, the economist toolkit can again include some sophisticated analysis studying the relationship between sales and profits, but also some so-called activity analysis looking at the nuts and bolts, if you will, of production. Let me mention one other issue related to lost profits, and that is the issue of price erosion. This is a somewhat different concept than the one we've talked about, which focuses on actual sales loss, i.e. sales are lower to the patent holder than they would have otherwise have been but for the alleged infringement. That is the core concept of a can-do-it analysis. But it is also possible for a plaintiff to lose sales, here a plaintiff being the patent holder, to lose profits, not because sales go down, but because their prices have been diminished as a direct result of the participation in the marketplace of the infringer. And one can imagine a scenario where, by way of example, there are 2 and 3 or 4 alleged infringers, and that competition causes prices to go down for all market participants, including the patent holder. And the argument here is that the patent holder's prices would have been higher, not lower. And as a result, the difference between what the prices would have been and what they were is also a potential measure of lost profits suffered by the patent holder in a world unaffected by the alleged wrongful behavior. Now, again, the concept of price erosion is heavily dependent on the fact pattern that is presented. But as economists thinking about the broad categories of lost profits, in addition to lost sales, one can also think about conceptually the issue of price erosion.
Before we move on to royalties, let me ask you this. Just going back to non-infringing alternatives, in your experience, how have you determined whether a non-infringing alternative is an economically acceptable substitute? And I guess, have you found that to be more of an economic issue or sometimes a technical issue?
Well, I think, Kevin, it's you won't be surprised that as economists that we tend to focus on the economic side of it. Many times the analysis starts out with a technical analysis of whether the products perform the same function. So in many ways, technical in nature. Is the same service or product providing the same type of technical function. But as economists, we also want to analyze more than just that and bring these additional concepts of economic substitution based on price relationships in addition to straightforward technical substitution. And by way of example, one might imagine that if people are at a hospital and they need to be warmed after coming out of surgery, which is not unusual, that you could use a blanket, a simple blanket, to provide additional warmth to someone coming out of a surgical environment where the surgical environment temperature is reduced for efficacy reasons as the surgeon performs the function at issue. But there are products that are called warming blankets, which actually provide additional warmth to a patient that is more technical in nature. And it may well be that although they provide the same technical and related substitution pattern, that they may not necessarily be, in an economic sense, products that are close substitutes because of differences in price, differences in efficacy with respect to the use of the product. Let me mention one other issue before we jump to the reasonable royalty issue, and that has to do with potential tension between the concept of lost profits and the concept of reasonable royalties, and focusing, on non-infringing substitutes in a lost profits concept. Now, this is a strategic issue, but I want to mention it because it does overlap substantively with how an economist approaches the issue. For example, if a patent holder is pursuing under Panduit a lost profits claim, they may articulate, again, depending on what the facts show, that there are, in fact, no non-infringing alternatives. It's not unusual in that fact pattern for the defendant to then bring a counterclaim alleging that the patent holder is a monopolist of the product at issue, and claim that there is a violation of the antitrust laws. Well, one might imagine that the defendant's first argument is that the patent holder is claiming that there are no non-infringing substitutes in order to achieve a lost profits estimate, and therefore they are by definition a monopolist. And I simply mention this because in thinking about the concept of lost profits, there is a relationship to a potential claim being made by the defendant as a counterclaim that may manifest itself through the antitrust laws. And as economists, we would have to analyze those issues in tandem. I apologize, Kevin. Let's now turn to the issue of reasonable royalties.
Okay, David, I can pick it up from here. That, the Panduit case lays out 4 factors that an economist needs to assess to demonstrate that a claim for lost profits is economically appropriate. Now, even if a plaintiff cannot demonstrate the economic appropriateness of a lost profits claim, the plaintiff is still entitled to receive what case law says is no less than a reasonable royalty as compensation for that patent infringement. And so there, you could see a number of situations in which this arises. So, for instance, you may have a patent holder that doesn't itself sell a product embodying the patented technology. So it could be that the patent holder developed certain technology and chose not to commercialize it. It could be that the patent holder is a non-practicing entity and bought the patent as a means of commercializing it. But there are any number of instances where the patent holder does not sell a product with that patented technology. And so in that situation, it simply wouldn't be plausible to argue, or in most cases, it wouldn't be plausible to argue that the patent holder is losing sales to an infringer. Or it could be the case, as David and I have discussed, that there are a number of competing non-infringing alternatives, and it would simply be too speculative or too uncertain to draw a reasonable conclusion that absent the defender's the defendant's infringement, that those sales would have gone to the plaintiff. So there are a number of instances where a plaintiff might find itself in the world of asking for damages based on a reasonable royalty. So as with lost profits generally being governed by the Panduit factors, there is a court case that is generally governing the determination of a reasonable royalty. And for those of you who frequently practice in the IP space, you've most likely heard of the so-called Georgia Pacific factors. And that is simply a court case from the 1970s in which a judge articulated 15 factors that he thought were relevant to the determination of a reasonable royalty. Now, I am going to jump ahead to the punchline because factor 15 is really what all the other factors are building up to. So I mentioned earlier in this presentation the idea of a hypothetical negotiation. So as its name suggests, it's a negotiation that didn't actually happen, but instead it is this idea of what would have happened if rather than infringing, the defendant had taken a license to the patented technology on the eve of its first infringement. Now, there is a lot in that statement. Simply the idea of eve of first infringement, one could write a paper about, or one could, in an actual case, get into a big disagreement about. But for now, just think of that as the first identifiable time in which the defendant was found to infringe. So the hypothetical negotiation then asks an economist to evaluate all the economic evidence that would have been at the party's disposal at the eve of first infringement and try to model what royalty would have been negotiated and what terms of a license would have been negotiated if the defendant had been trying to avoid infringement by taking a license. Now, the hypothetical negotiation does not occur in a vacuum, that an economist needs to account for the economic circumstances that would have been issued back at that time of first infringement. However, as I say that, I am sure David would remind me that there is a construct in IP damages known as the so-called Book of Wisdom, and that in certain circumstances, it is appropriate to look forward in time to, in a sense, be prescient as one of the negotiators and know what might happen in the future. So generally speaking, economists will look at the information and the economic circumstances that were known at the time of the first infringement. However, if there is a market deviation from what was known at the time of first infringement, that in certain circumstances, it is appropriate to look forward in time and to rely on this so-called Book of Wisdom. So for instance, a few years ago, I was retained to work on a case involving the coal mining industry. And at the time of the alleged wrongful conduct, coal was selling at a very elevated price per ton. Literally just a few months later, the price of coal began a decades-long decline as the climate change movement started to ramp up and as various power generators or electricity generators started a wholesale shift away from coal. And so never again was the price of coal anywhere close to what it would have been at the time of that negotiation would have taken place. So that is the sort of situation in which economic factors or market factors change dramatically, literally just a few months after the negotiation would have happened. And so solely confining oneself to what would be known as ex ante information likely would have given an economically unreasonable result. One other thing to note on this slide is that the hypothetical negotiation needs to account for the form the royalty would have taken. And generally speaking, there are two different forms to a royalty, either a lump sum royalty or a running royalty. And both of those terms are fairly self-explanatory. A lump sum royalty is one payment that is exchanged between the two negotiators at the time the license is signed, or at some defined point in the future, or at some milestone achieved by the product. The alternative is a running royalty, and that is most often applied either per unit of infringing sale or as a percentage of either sales or profits for the infringing product. And David and I will come back and discuss these issues in a few moments.
So let me run through the other 14 factors relatively quickly here, because as Jeff mentioned, what these factors are designed to do is to try to guide the investigation to the economic relationship between the parties and the relevant economic factors that would affect that hypothetical royalty rate. You won't be surprised, for example, number one is, did the patent holder actually license the patent in suit to somebody else? And if they did, obviously, that would be relevant, not necessarily outcome determinative, but relevant. Did they license the comparable patents to other parties, and what were those rates? Is the patent going to be exclusive or non-exclusive? Obviously, if it's exclusive, it's going to have a potentially different rate than if it's non-exclusive. What is the licensing policy of the patent holder? For example, do they usually license their patents on a running royalty basis, i.e. per unit, or is there a lump sum? What is the commercial relationship between the licensor and licensee? For example, are they competitors or not? If we look at number 6, is the patented product being used to promote the sale of other products? This is the concept so-called convoyed sales. What's the duration and the term of the license? That can obviously have an impact. What's the established profitability of the product? The commercial success of the product? What are the advantages of the patent? What are the benefits of the patent to those who have made use of it? What is the portion of the profit that goes to the actual technology at issue? For example, if you have a product that has 100 attributes and the patent relates to just one of them, how much of the profitability and the success of the product is attributable to that incremental issue? And that's also memorialized in 12 and 13, how much of the value is credited to the invention, distinguished from non-patented elements. And 14 actually is the one Jeff and I like, which is, what is the opinion of qualified experts in reaching judgments about the Georgia-Pacific factors? Now, just a couple of other general comments about Georgia-Pacific. It is not an exact science. Again, it's designed, even within the construct of the decision itself, to be a guideline to the types of factors an economist would analyze in trying to reach an opinion, an informed opinion about what a reasonable royalty might be. Historically, there had been some rule of thumbs, particularly something called the 25% rule, which is that if it were difficult to make a judgment about what a reasonable royalty might be, that one would decide that well, 25% of the profitability of the product could be used as a guidepost. That is no longer admissible by the Federal Circuit. Obviously, some factors in Georgia-Pacific may be more relevant in a particular case than another, and it is important, despite that fact, to try to take into consideration, at least conceptually, all of the factors in making a judgment. But again, the overriding point here is that these are factors designed to get at the economic circumstances that would be relevant in that hypothetical negotiation that Jeff mentioned. Again, we've talked a little bit about this. Prior licensing is obviously very relevant. The reason it's not dispositive is that you might license the product to company A for X%, but company B might be viewed as a direct competitor. And you might be more concerned about the impact that that firm might have on your ability to market the patented technology. And so obviously prior licenses are very important, and depending on the circumstances might be outcome determinative. But again, you have to look at the idiosyncratic fact pattern in reaching to those judgments. If the patent holder had gone out to a bunch of potential licensors, and they had all rejected the licensing the patent, that could be relevant. Licenses of comparable products. All of these are relevant in making an analysis of the value of the patent. Something else that's very important is whether the patent holder had actually done any internal valuations of the patented technology. Did they value it? Or did they have a third party value it, such as a Ernst & Young or a McKinsey or somebody else who might value it? And obviously, it would be relevant if the alleged infringer had made a valuation of the patented technology. Again, if the patent holder is making a valuation, if the infringer is making a valuation, if the patent had been licensed before or been failed to be licensed, these are the types of real world things that fit into the Georgia-Pacific factors analytically in trying to reach a judgment about what a reasonable royalty is.
So just to follow up on that, David, that all of these are the sorts of information that one would consider as part of a hypothetical negotiation. That there is a term known as both sides have their, quote, cards face up on the table. So it's this idea that both parties are working from the same set of information. And so the infringer would know, for instance, if the patent holder had gone out and tried to obtain a license from dozens of other companies and had been unsuccessful in doing so. The infringer, the defendant, would also know if the patent holder had obtained third-party valuations. And so in light of those sorts of circumstances, it would be tough to come up with an outcome to the hypothetical negotiation that differs significantly from the information known to both parties. That unless there were some sort of overriding economic circumstances, if the patent holder had tried to obtain dozens of licenses and had been unable to do so, or if the patent holder had internally valued a technology at a small amount and was now asking for a huge amount, there would appear to be an inconsistency there. And there would need to be some sort of overriding economic justification for coming up with an outcome to the hypothetical negotiation that differs significantly from the real world economic circumstances that would have existed.
And I'm going to take this moment to interject with the CLE code. If you are seeking CLE credit, please write this code down. It is K as in Kevin, C as in cat, the number 3, the number 4. I'm going to repeat that 2 more times. K as in Kevin, C as in cat, 3, 4. And again, that is KC 3, 4. Thank you.
So the important aspect of this slide is really bullet point 2, talking about the incremental benefit of the patented technology. As economists, David and I have been trained both through our education and the course of our careers to really think about the incremental change in something. And here the idea is, what is the incremental change of the patented technology relative to older technology or relative to non-infringing alternatives? So, when David was quickly running through the list of the Georgia-Pacific factors, a lot of those factors related to what is the incremental profit created by the use of the patented technology, or what is the incremental benefit stemming from use of the patented technology. And it's really that incremental difference that David and I, as economists, would believe forms the basis for the economic value of a patent and would really form the basis for what the parties would be negotiating over at a hypothetical negotiation. So there are any number of ways of measuring incremental benefit. And David and I have alluded to many of those today. One could use statistical analysis. One could look at market research or market evidence. But one way that we haven't discussed that is seemingly gaining some popularity is the use of surveys. And so it may be possible to conduct a survey of consumers, for instance, to determine the value that they place on this technology. Now, a survey may not be dispositive. A survey might have to be considered certainly in juxtaposition to all sorts of other market evidence and perhaps statistical evidence. But there could be real value to using a survey and getting actual consumer feedback on how they view the technology and what value they place on the technology or what benefit they gain from availing themselves of that technology. But again, as David and I say in bold at the bottom of this slide, and as David and I have been emphasizing throughout this presentation, each case is different. Each case will have its own unique set of economic circumstances and economic factors that one needs to evaluate. And so just because a certain technique might be relevant in one case, doesn't mean that technique would necessarily be relevant in any other case.
These are some important questions to investigate, and I have actually mentioned each one of these. And if you could flip the next slide, Jeff, I think I can bring these to life by briefly talking about a few actual cases. The Amato Microsoft case was a case brought by an individual, Mr. Amato, claiming that Microsoft had infringed a certain patent that went to the Access product of Microsoft. And Mr. Amato was claiming hundreds of millions of dollars of damages. This was a case in which the plaintiff, Mr. Amato, had done an internal valuation of his own technology at a value of substantially less than what he was seeking in damages from Microsoft. He also had a third party do a valuation of the patent. He also used the patent to try to borrow money, and that was at a very different valuation. And so this is a real world example of how internal valuations by the patent holder can have a significant impact on the outcome. In this particular case, the plaintiff did not collect hundreds of millions of dollars from Microsoft. The award was relatively small relative to what they were asking for. In the Deshib Genentech case, that was actually a trade secret case. And there, the plaintiff was using business documents of Genentech. And so this goes to the issue of value put on by the defendant. But the documents were for a product that had not yet been introduced in the marketplace. And there were serious questions about the reliability of those documents. And in that particular situation, the trade secret holder, Dr. Deshib, also employed an expert who did an analysis where they claimed that when Genentech made certain announcements about this particular product, there was a change in their stock price. Unfortunately for Dr. Deshib, the expert in that case, I was against that expert. It turned out that when Jeff and I investigated his so-called event analysis, where he claimed that the announcement surrounding this product that Dr. Deshib claimed that he had the secret to, that the stock went up, he actually picked the wrong day and the stock went down. Dr. Deshib was not awarded any damages. Cruzy is another example that's relevant to these important economic factors. Here, the plaintiff tried to license its patent to many of Caterpillar's competitors. This related to fuel injection. None of them were interested because they had other ways to accomplish the same goal. This gets to an issue that Jeff and I have not mentioned, but is quite relevant in these reasonable royalty negotiations, which is, what is the possibility of a design around? Is it possible for the alleged infringer to design around the patented technology in such a way to accomplish its own goals? Again, the design around issue is not itself outcome determinative, but it can be extremely relevant depending on the facts of a particular case. Augustine Medical was a price erosion case, and I'll leave the last one to Jeff.
Well, and the last one, Wyeth versus Teva and Son, also involved price erosion. That Teva and Son launched at risk with a generic version of Wyeth's drug Protonix, which is a so-called proton pump inhibitor. The interesting thing in the Wyeth case, though, is that Teva and Son did not launch at the same time. Teva launched about 2 weeks before Son. And so Sun hired my firm at the time to analyze the incremental effect of Sun's launch. That for those of you who have done at-risk generic launches, you know that there are a number of economic factors that almost immediately transition the market from the branded drug to the generic drug. And those factors were set in play at the first availability of Teva's generic drug. And so Wyeth was going to lose some significant portion of its sales, regardless of whether Sun launched or not. And so Sun wanted its own expert to analyze the incremental effect of its generic launch. And so that was particularly relevant with respect to price erosion. Just one final point to address here is that we've been talking about a reasonable royalty. Now, obviously, a reasonable royalty has to be applied to something. It has to be applied to some base, which is known as the royalty base. And so oftentimes that is the number of units sold by the infringer, or it could be the dollar value of the infringer's sales or the infringer's profits. And so I don't want to get too deeply into this slide, but suffice it to say that it is important to understand if your royalty base is accurately reflecting the patented technology or not. So David and I have mentioned a couple of times multifaceted products. So think of a computer or think of a bit of software that might contain hundreds, if not thousands of components. If one were to apply a royalty of, say, 4% of sales to the entire price of a computer for a component that represents just some small portion of that computer, that would likely have the effect of overcompensating the plaintiff, unless the plaintiff could specifically indicate that that small component was the overall driver of that computer's sales. And so the Federal Circuit increasingly is asking economists to make sure that the royalty they're applying is being applied to a base that accurately reflects the infringement at issue. And so I think this last slide that we have specifically deals with relief for patent infringement at the ITC. And so since this is really the focus of Kevin's practice, let me turn it over to Kevin for a moment or two.
Yeah, so at the ITC, as you know, Jeff, there are no monetary damages. The ITC, the remedy that ITC can provide is an injunction preventing respondent from importing its products into the U.S. at all, which is obviously very, it's got profound business impact, right, if you can't import your products into the U.S. But in the ITC, we often do use economists to analyze several issues, two of which are domestic industry, which is whether or not the complainant has a business worth protecting in the United States. And the other issue is public interest, which is whether or not it's in the public interest, or at least not against the public interest, to block certain products from being imported into the U.S. And Jeff, I understand you've actually done several ITC cases yourself where you've provided testimony.
Yes, that's definitely the case, Kevin. Well, I think we are just about out of time, but this is a great slide to leave off on, and I think, Kevin, perhaps it suggests a follow-up course specifically dealing with some of these issues.
Yeah, an ITC course would be, I'd be all for that.
Well, thank you so much, Kevin, for moderating for us today.
Thank you all so much.
Thank you very much.
On behalf of the DC Bar and the 2020 Conference Planning Committee, I'd like to thank our speakers for taking the time out of their busy schedules to present on these important topics. As a reminder, please be on the lookout for the email from the CLE staff to submit your codes for credit, as well as to complete the class evaluation. Feel free to send us an email at cle@dcbar.org if you need any help. We look forward to seeing you at future programs, and thank you. Hi, I'm Dennis Cuevas, Director of the CLE program at the DC Bar. We hope you're enjoying this virtual conference marking the 100th anniversary of the 19th Amendment. This session, Navigating Workplace Culture in the Age of the Me Too Movement, is eligible for CLE credit in all states that have continuing legal education requirements. An alphanumeric code will be read out loud and displayed sometime during the presentation. Please take the time to write down the code. Within the next 24 hours, those of you who have registered and paid for CLE credit will receive an email with a link where you will then identify the correct codes to receive credit. As we enter our busy season with many state CLE deadlines fast approaching, please allow up to 30 days to process your certificate. Also, in that same email, there will be an electronic evaluation form. Please take the time to complete the evaluation. We need a significant number of them back for accreditation purposes, but more importantly, we review them carefully as we always look for ways to improve our classes. If you have any questions about obtaining CLE credit, feel free to send an email to cle@dcbar.org and we will be happy to assist you. If you're watching this pre-recorded program during the live broadcast, please feel free to pose any questions you have in the chat room since our presenters will be available to answer questions at that time. Now, without further delay, let me turn it over to our distinguished speakers. Enjoy the program.
So welcome everyone to this session on navigating workplace culture in the age of Me Too. My name is Gage Javier, and I am an attorney in the Washington, D.C. office of Buckley, where my practice includes workplace cultural compliance. So in this session, we will explore how the Me Too movement has turned new attention to issues of workplace culture, sexual harassment, and gender equality, and what we know about shifts in public perception around these issues. We will start out with an overview of the workplace landscape, discuss the recent developments in workplace protection laws, and then round out with some of the best practices in building a positive workplace culture. I'm joined today by Emily Martin, Vice President of Education and Workplace Justice at the National Women's Law Center in Washington, D.C. Prior to joining the NWLC, Emily served as Deputy Director of the Women's Rights Project at the ACLU, where she worked to advance the rights of women and girls. Emily, welcome.
Thank you. Thanks for having me.
I'm so glad we are having an opportunity to chat today about this very, very timely and very important issue about how to navigate the workplace culture in light of the Me Too movement and how we can best create the best practices on how to make our workplace as inclusive and as safe as possible. So in terms of talking about the perception of workplace culture, when we talk about issues surrounding that subject, what exactly does that entail and why is it important to address these issues?
Well, obviously, workplace culture is a term that can mean a lot of things, but one of the things that I think the Me Too movement has really made clear is part of workplace culture is how do workplaces approach issues of equity? How is your workplace safe? Is it dignified? Is it respectful? So when it's not, the folks who have the least power in the workplace tend to bear the brunt of that. And more often than not, those power lines go along lines of gender, along racial lines. If you are in a job that pays low wages, you probably have less power and feel the most toxicity in a toxic workplace. So when we talk about creating a safe and dignified and respectful workplace culture, what we're really talking about is creating a culture where workers are able to do their best, to be fully themselves at work. And ultimately creating that sort of culture is not just in the interest of employees, though it is certainly in the interest of employees, but it's also in the interest of employers because it allows employees to show up and do their work without having to be dragged down by toxicity every day.
That's a really great point, and especially when you're talking about dealing with a workplace that there is a sense of toxicity and it makes people uncomfortable about raising any issues within the workplace itself. So I guess if we're looking at before the Me Too movement began, what do you think were some of the public's general perception of even having to address those type of issues in the workplace?
Yeah, I mean, I think that before 2017, when Me Too went viral, there may have been a sense that while sexual harassment is a thing that people knew about, that it was a kind of rare thing, that it was a one-off problem, that it was the exception rather than the rule. And one thing that I think has really shifted in the past few years is so many people have come forward and shared their experiences from so many different industries, so many different walks of life, is a shift in understanding that this is still very much a problem that we have not solved, and that it penetrates across workplaces, across industry, that nobody's immune from it. And I think it's not just about sexual harassment. I think it has also driven a broader public shift in perception around gender equality and what is the work that we still have to do. There's a pollster named Tressa Undum who did some polling in late 2016, right after the presidential election, and then went out with similar questions in 2017 after Me Too had gone viral. And in late 2016, 65% of people surveyed said that men had more positions of power in society. A year later, 87% of people said that. So it really shows how Me Too was a moment of shifting our understanding of sexual harassment in the workplace, but also sort of shifting broader perceptions about gender and power at work.
I think that's a really great point when you're talking about the shifting power concept, and especially when it comes to how people even perceive harassment in the workplace itself. I was doing a great deal of presentations and trainings with various entities and organizations, and as part of that, I came across the 2018 survey by NPR, and I think some of the most astounding statistics I think that I came across, for example, was that 81% of women and 43% of men have experienced some kind of harassment or assault in the workplace. 41% of employed men have witnessed sexual harassment at work. 67% of adults believe that sexual harassment takes place in most or almost all work environments. And of that subset, about 62% and 71% of women believe that to be true. And I found that statistic so completely astounding because it highlighted really two things, right? So if we're looking or we're thinking when we're talking about, harassment in the workplace, ultimately what some people immediately think of is that women are the main targets of harassment. But from that statistic alone, when we're looking at 43% of men having experienced some form of harassment, that includes them in that conversation. So this idea that workplace culture and harassment is only, applicable to a certain subset of individuals within the workforce is not actually true, because men are actually quite involved in it, and I think that makes it much more difficult for them to ultimately raise some issues, because it might not be expected for them to raise issues because of it being harassment in the workplace. And I think the second point that that survey really brings home is that nearly 2/3 of the workforce believe that you should just expect harassment in the workplace. I mean, that's a fairly astounding statistic that I think conversations like this will be really helpful in hoping to drive down those numbers, because that's an astounding number of people that think that they just need to prepare themselves for that kind of interaction at work. So so that being said, what do you think is the contribution? What are some of the contributing factors, to this kind of perception that you should just expect that maybe 2/3 of your peers might have this kind of experience?
Well, I think one contribution to that expectation is the fact that over the past few years, we have heard so many people come forward with their experience. We did some polling at the National Women's Law Center just recently, and of the folks we polled, 15% of adults, including more than 1 in 4 college-educated women, have shared their own Me Too story in the past couple years. And when you think, that's not a survey of have you experienced harassment, it's have you sort of testified about this experience to your community? Have you shared this? And it's a really high number, I think. And because it is ultimately, I think, a positive thing that we have a deeper understanding now of how common harassment continues to be. But that can lead to a perception that it's inevitable. And at the National Women's Law Center, what we do is try to create change through policy, through law. And so part of our charge that we have really taken up in the past 3 years is putting forward solutions and trying to explain how, yes, we haven't fixed it, but that there are ways to make a difference. And I think that there's been a lot of openness and interest in that conversation about what do solutions look like, how can we get there, that didn't exist, say, 5 years ago.
And so in terms of working towards that solution, what do you think are some of the main obstacles that people are finding that get in the way of creating something that's effective and efficient in terms of addressing workplace issues?
Yeah, I think they come from a variety of places. I mean, certainly there is some backlash and fear that creates obstacles. This polling that we recently did, 58% of adults think that Me Too has changed how men and women interact at work. And among those who say Me Too has changed workplace interactions, close to half say those changes have been for the better, but 21% say it's been for the worse, and 31% say both for the better and the worse. So I think that there's definitely concern that taking harassment seriously leads to men being more afraid of mentoring women. It's a fear that we certainly hear about a lot. It's a little less clear whether, before Me Too, all these men were having tons of women who they were mentoring, but there's a paranoia that if we talk about harassment in the workplace, maybe as a male employee, I'm no longer safe, and that can lead to resistance in taking steps to change workplace culture. And ultimately, one of the things that we talk about a lot is how harassment in the workplace comes down to power differentials. And unfortunately, one of the things that means is addressing harassment in the workplace means taking on power, and people are not eager to give up power. So that sort of retrenchment, that sort of backlash is a set of obstacles that we have to navigate when we try to shift how we as a culture, we as a workplace respond to sexual harassment.
I think that you raise a really good point where there is that backlash, right? Because when we think about sexual harassment, it's not always about sex, but it is always about power, basically trying to determine where the shift in the power will lie. And from an employee perspective, you're looking at it as, if I raise these issues, will there be any form of retaliation? Is it even worth raising the issues because either the person who is the perpetrator of that kind of harassment is in a position where there's just too much power, maybe perhaps they're a supervisor, or perhaps they're a state legislator that has been in the system and been in the political sphere for so long that they've amassed so much power that it's gosh darn near impossible to be able to raise any issue and have them address those issues because of the fact that they have all that perceived power. And so I think what was really interesting about what you said is, how do you then shift that dynamic within the workplace then, so that the person themselves can feel like they can raise those issues in a way that will also still preserve their livelihood. I think some of your work, for example, that you had addressed a lot of issues for low wage workers. They might feel like they don't have that kind of opportunity to raise those issues, because if they work on an hourly basis, they potentially couldn't have a job tomorrow, right?
Right. Yeah, and in low wage jobs in particular, where sort of by definition, your work isn't highly valued by your employer, it can feel as though you're both very easily replaceable. And so, yes, at high risk of retaliation if you are coming forward. And also the stakes can be really high. If your family is one paycheck away from financial crisis, taking the risk of retaliation, which is a real risk when someone complains of harassment in the workplace, that risk may seem just way too big to take. And in addition, often the conditions of low wage work itself can exacerbate harassment. So, for example, if you're in a customer-facing role, like you wait tables in a restaurant or you tend a bar, that idea that the customer is always right can lead to an expectation that there's a certain amount of sexual harassment to just put up with for the good of the company. If you're a tipped worker, you might feel like you have to put up with that harassment just to have any sort of adequate wage. And then there are other sets of concerns that workers who work in isolated positions in low-wage jobs experience, whether farm workers or janitors, where that isolation also can create risks of sexual assault and sexual harassment.
So in those instances, whether or not it's going to be in work, low wage employment or even white collar positions, how have you found, in terms of the impact in the workplace and how the Me Too movement has impacted the workplace, how have you found organizations responding to address those issues so that, even places like where they typically go on an hourly wage, for example, might feel like workers can actually feel like they have a choice and some semblance of power?
Yeah. Well, the first thing to know is that a lot of organizations are responding to harassment in recent years. Our recent polling shows that 26% of employed adults say their employer has done something new in the past few years around helping to prevent sexual harassment. And a thing that we didn't especially expect, which is really interesting, is that folks who say their employer has done something new express more favorable views toward Me Too, toward that movement, than those who say their employer hasn't. So, for example, 61% of Democrats, we did this by party for some of these questions, 61% of Democrats whose employer has made some change as a result of Me Too feel very favorable toward the Me Too movement, versus 43% of Democrats whose employer hasn't done anything new. And it really suggests the importance of employer leadership in driving culture on these issues. So some of the specific things that employers have done, I think there's a real range from taking training more seriously and really investing in training that's interactive, that's one-on-one, that takes into account the particular context of this workplace rather than just being, a video that everyone has to play on their computer that was made 20 years ago, to other sorts of context-specific interventions. So, for example, there's fascinating work that has been done by a coalition of Immokalee workers. It's a farm workers group to get buyers from farms to demand that farms take a pledge around various safety practices that they're going to institute in order before the buyers will buy from those farms. And the workers themselves have really been leaders in creating these pledges, these policies, and in enforcing them. So it's a really innovative and exciting way in which worker leadership in low-wage jobs has really been transformative in workplace culture.
That was actually a really good point, where taking a look at how effective a movement like Me Too can be is strong. It is largely also based on an individual or an employee's perspective on whether or not their own employer has made the changes to be able to do that. And I think that also goes to show you that if there is buy-in from the stakeholders, if the stakeholders themselves are pushing the issue and raising the issue and not letting up on that kind of pressure, you can certainly make a great deal of change, as you can, as you basically pointed out in that farm example. And I think that's something that organizations and leaders in organizations should take note of, and especially if you are an employee in any organization, that if this is an issue that is important to you, to constantly raise it so you can still keep that forward momentum going, so that you can generate more buy-in from colleagues and allies that will drive the conversation forward. I think that that you've also seen and shown that that can have a great impact on whether or not there's actual change in the organization itself.
Absolutely.
And in terms of, I know that you talked about the smaller organizations. Any other types of organizations and how they've basically responded to that movement?
Well, I think that another example that occurs to me that has been both a subject of legislation, but also a subject of employer action without legislation, is panic buttons. So hotel employees, for example, hotel housekeepers have successfully advocated for having panic buttons. So if they are sexually harassed or assaulted by a hotel guest, that there's an ability to get help right away. There's been sort of similar employee-led advocacy among those who work on custodial teams on the night shift, to make sure that there's a buddy system, to make sure that that you're not going to be all by yourself in a dark building at 1 a.m. if your coworker downstairs could be a threat.
That's actually really incredible how there are some places where that buddy system needs to be put in place. I know that there is also some state legislatures that the state representatives have also had to implement their own buddy system also, which is kind of telling. And the response to that, I think that what I've seen is that state legislatures have also have taken the time to create training sessions and policies where they're trying to address those things. And, I think in 2018, there was like 125 pieces of legislation that talked about training and harassment within state legislatures themselves, and trying to create that sense that you don't need to have a buddy system anymore. This is something where you can have that type of conversation, between colleagues, and it's a safe space to be able to do so. And also even in law firms, once the Me Too movement has pretty much gone their way, you saw a lot of law firms looking at their own internal policies, trying to assess whether or not, they actually have as robust a policy as possible. Is there, for example, a reporting process? Is there an investigation process that is very clear cut, that any, staff member or attorney or partner, whoever is employed by a law firm, to evaluate their policy and see how effective they truly are, and even to the point of whether or not, if there is actually a report being made on harassment, that they might even have to include a third party to help with that assessment and kind of chase that issue down. So it's definitely great to see that there is this forward-moving change on workplaces and even leaders within this workplace. So that being said, a lot of this also stemmed from 2017, Harvey Weinstein, and basically everything that happened in Hollywood and the issues that came out of that. How effective do you think, or really what role has litigation, do you think, really played in bringing workplace issues to the public's attention?
I think that even before Harvey Weinstein, one of the ways in which litigation helped bring these issues to the public's attention in a way that was relatively new was when Gretchen Carlson brought her case against Fox News and Roger Ailes specifically. And that was earlier in 2016, but helped create a new level of public attention around the ways in which mandatory arbitration and non-disclosure agreements could empower sexual predators. And so I think it's a great example of how a legal fight can shift the background of public perception, of public feelings on a set of policy issues. Since that case, which she had this clever legal theory where she sued Roger Ailes personally rather than Fox as a corporation, and had an argument that her mandatory arbitration agreement, which otherwise would have kept this out of court and in secret proceedings, didn't apply for this defendant. That case both brought attention to the ways in which sexual harassment can happen to you, even if you're rich and famous and powerful. And it also created this new interest around forced arbitration, which before had been a very niche issue that organizations like mine would explain what it was and why it mattered. And suddenly, and certainly in the years since, there's been a much deeper understanding of the ways in which access to the courts is critical for justice for folks who've experienced harassment, and the ways in which mandatory arbitration can prevent that and can prevent meaningful accountability. So I think that litigation is necessary but not sufficient for all the changes that we need, but it's a really important tool. Another example that I'll give that we are very proud of at the National Women's Law Center is the Time's Up Legal Defense Fund. After Me Too went viral, then Time's Up went viral, and millions of dollars were donated to the Time's Up Legal Defense Fund, which the National Women's Law Center administers and operates. And what that fund does is it supports litigation by individuals who are challenging workplace sexual harassment, or folks who have spoken out about workplace sexual harassment and are now being attacked in the courts by their harassers with defamation lawsuits or other sorts of attempts to retaliate through the law. And so the whole vision of that effort is the notion that the courts are a really important way of seeking justice. And that is true both for the individuals whose cases otherwise wouldn't have been brought because they weren't profitable enough for any attorney to bring them. But it's also true for the broader public, that those cases, that those stories, the McDonald's workers who have come together to challenge harassment at McDonald's franchises across the country, that also moves change by telling those stories through the courts and in the press when litigation happens. That all of that helps shift our culture in important ways.
So, trying to make that shift, it seems to me, especially when it comes to litigation, it's either you work in a class and then bring the litigation forward, or you're in a position where you have the financial backing to be able to even pursue any kind of lawsuit against your harasser. So in instances where they're, kind of like your McDonald's issue, your McDonald's example, in certain situations where the employees themselves are low-wage workers, what types of obstacles have you seen, have they been able to overcome or to be able to raise those types of issues and maybe bring these types of cases to light? And, are there any other remedies for them? Because, they don't have as much financial backing and funding available to kind of pursue that through litigation.
Yeah, we talked about how if you work at McDonald's, you might have good reason to fear retaliation and losing your job if you challenge harassment. But say, for whatever reason, you've already left that job, you feel able and ready, there's still a real barrier that you may face in finding an attorney to help you make this case and move forward. For example, legal aid and legal services offices in most parts of the country, there are some exceptions, but lots of them don't do employment law. These are big, complicated cases, and the majority of legal services offices just don't have the resources to staff that. So if you do not have a legal aid attorney who can take on such a case, and you don't have any ability to pay out of pocket, you're going to have to find an attorney who believes that they can get enough at the back end through an attorney fees awarder, or more likely through a contingency, through a part of a remedy to make it worthwhile. And part of the problem for workers in low-wage jobs is that even if you've lost your job as a result of the harassment, if the wages that you lost are objectively not that much, it puts a cap on what your legal recovery is likely to be, which can make it harder to find an attorney to bring that case. And so the Times of Legal Defense Fund is one response to that problem. Obviously, we can't support every case in the world, but the fund was created, and the way in which we do our work is really meant to shift the decision making of the private bar on these cases by providing some upfront funding to make it possible to bring the case where injustice was done, but it just didn't make economic sense for the attorney to take on the matter before. And so it's been exciting to be able to help ensure that an advocate was available for women and some men. We also have cases where men are plaintiffs who otherwise wouldn't have been able to have any real recourse.
And that's half the battle, right? Like, what is the actual recourse for any of these employees? And some of that is going to be through litigation, but some of that is also through legislation in terms of the types of protections that an employee might have depending on where they are. Now, I know that you have a slide talking about the legal developments within this space, and I recall in 2019 that there was the Be Heard in the Workplace Act that was introduced in the House. And so I'd love to kind of get your take on, how do you think this would change the legal framework in terms of prohibiting discrimination?
Well, so the Be Heard in the Workplace Act is a bill. It has not passed, but what is exciting about it is it's a sort of comprehensive vision of how we need to update and expand our protections against harassment and other forms of discrimination under federal law. So some of the key things that the Be Heard in the Workplace Act would do, it would protect more workers. So right now, Title VII only applies to employers with at least 15 employees. It doesn't protect you if you're an independent contractor, if you are a volunteer or an intern. It's not completely clear that you're protected. The Be Heard in the Workplace Act would change that. It would reach independent contractors. It would reach all employers, even small employers, and ensure that those protections against harassment and discrimination are available to everybody. So that's sort of a baseline fundamental protection that I think most people assume we have under federal law, but that lots of working people actually don't. It would also update some of the tests that courts apply in sexual harassment cases. So one of the things that courts ask when you bring a harassment claim is whether the harassment is severe or pervasive. And different courts have interpreted that in different ways. And there are certainly decisions out there that basically say, yes, he grabbed your breasts, but only the one time. That wasn't that big a deal. It doesn't meet the standard under federal law. So the Be Heard in the Workplace Act would update that severe or pervasive standard, would make clear that there isn't a minimum number of events that you have to have in order for it to constitute harassment. It would ensure that courts look at issues like the power dynamics in a particular interaction. and would make clear that that one incident can be enough to meet the test. So that's another important thing that it would do. It would also ensure that there are meaningful remedies available if you prove your harassment or your discrimination case. Right now, Title VII puts a cap on damages based on how big the employer is. That cap was set in 1991 and it is not scaled to inflation. It has not changed since then. So for smaller employers, $50,000 is the most that you can get in your lawsuit, no matter what damages you experience. And so it's easier for employers to write some of these risks off as just the cost of doing business. So the Be Heard in the Workplace would remove those caps. It would also extend the timeline for when you can bring a charge of harassment or discrimination. Right now under federal law, depending on what state you're in, you either have 180 days or 300 days to make a charge to the EEOC. Those are really short windows, especially if you're thinking about something like sexual assault, which, among other things, really is traumatizing. So the notion that if you're raped at work, that one of the things you have to do immediately is start figuring out your legal strategy and getting your charge together and finding an attorney, it's just not real. It's not realistic. So it would, the Be Heard in the Workplace Act would extend those time periods, including for federal employees who have to bring a charge within 45 days of experiencing harassment or discrimination. So to extend the timeline to 4 years for all employees. The Be Heard in the Workplace Act would also have new restrictions on employers' use of non-disclosure agreements to prevent employees from talking about harassment and other forms of discrimination. It would ensure that employers can't force employees into arbitration of workplace-related claims, that employees would retain the right to go to court if they wanted to go to court. And it would provide a lot of funding for legal services for workers in low-wage jobs, so that it's not just the Time's Up Legal Defense Fund and philanthropy supporting these efforts, but that there is a real infrastructure within the country to help working people enforce their rights. And it would have also new requirements around training, around harassment policies, around prevention. So it's an exciting vision of where we could get to. And it's also exciting because it provides a model for states to take action until we are at a day when federal government can pass these laws.
I think you brought up a really great point where, this act is going to be so helpful for a swath of employees who might not generally be covered prior to this, basically. For example, like state legislatures, their policies oftentimes, to your point, only cover state employees to some degree, but if you are an employee or who happens to be on the personal staff of a legislator, you might not actually have any remedies available to you because none of the policies apply to you. None of the state laws and statutes actually cover you. And so then the other flip side is, if you're an intern in those spaces, in that public sphere, for example, are you going to be covered? And do you have any remedies? And also, even if you are also, other independent contractors, you're a consultant, if you are a lobbyist, I think this Be Heard in the Workplace Act will certainly help with a lot of that coverage and be able to give people more remedies to that. So, in addition to this hopeful bill that will pass in the House, hopefully we're crossing our fingers, what other state legislation have recently come into development that's surrounding the workplace harassment and training requirements that you've seen start to change over time and have been introduced?
Yeah, well, for us at the National Women's Law Center, we really saw a sea change after 2017 when Me Too went viral in terms of state policymakers' interest and willingness to engage around these issues. So if we go to the next slide, since 2017, we've seen workplace harassment reforms in 19 states. Our campaign was 20 states by 2020. We are still one away, but 2020 is not done yet, so we might still hit it. And I will tell you, as somebody who works at the place where lawmakers call and say, we want to do a thing. Do you have a model? Do you have an idea? Before 2017, we heard from folks who wanted to do something on sexual harassment maybe once a year. After 2017, we've heard from legislators, maybe literally in every state in the country. I mean, it's just been a huge shift in energy and attention to those issues. So if we go to the next slide, we see activity in a variety of different sort of main categories, main spaces. I probably should rattle off the 19 states. The 19 states, if you didn't immediately pick it up from the map, are Arizona, California, Connecticut, Delaware, Hawaii, Illinois, Louisiana, Maryland, Nevada, New Jersey, New Mexico, New York, Oregon, South Dakota, Tennessee, Texas, Vermont, Virginia, and Washington. So it's not only a pretty long list, it's a list of states that come from different political profiles, which I also think is a really encouraging and hopeful sign about the fact that we're seeing real change here that's penetrating in a lot of different places. So the sorts of protections that states have enacted, like the Be Heard in the Workplace Act, states have paid attention to expanding their protections to all working people, or at least to more working people who are protected under state law previously. So independent contractors or unpaid interns or smaller workplaces. And as an example, New York enacted legislation that protects contractors and subcontractors and vendors and consultants and others who provide contracted services from harassment, but also from other sorts of discrimination. And New York also extended anti-discrimination prohibitions to all employers, regardless of size. So really a big shift in the way that we are thinking about how our civil rights law works in the workplace. And the next slide, there's also been a lot of attention to increasing transparency and accountability in state reforms. There's been a lot of attention to non-disclosure agreements, in part, I think, because of the Weinstein story and the ways in which non-disclosure agreements were abused to really hide this terrible pattern of harassment and assault over the years. 15 states since 2017 have either prohibited or placed limits on employers' ability to require employees to sign non-disclosure agreements, either as a condition of employment, which is the way this sometimes works, that you get the job and part of the set of papers you get on day one is, this is the non-disclosure agreement, making clear that you're not going to talk about anything that reflects badly on your employer anywhere out in the world. And if you do, we can sue you. So a lot of states have prohibited those sort of front-end NDAs as a condition of employment. And then there are also NDAs that come up in the context of a settlement agreement or release of claims, and where frankly the issues are a little more complicated, because there too, non-disclosure agreements can really be abused and be a way to enable a serial harasser to continue sort of undetected for many, many years. But also, there is concern among a lot of folks who represent plaintiffs that if you just prohibit NDAs and settlement agreements, that you make it harder for a plaintiff, for a victim of harassment, to be able to come to some sort of out-of-court settlement, which is probably always what you want. Litigation is always the least attractive option. And it's also the case that sometimes for the victim of harassment, there is a real appeal to confidentiality, and to have confidentiality go both ways, since it's seldom the case that that the fact that you were sexually harassed in your last job really makes you more attractive to a new employer. So there have been a variety of approaches to NDA reform in the context of settlement. One example of an interesting approach is a law that California passed, which prohibits NDAs if a charge has been filed. So it allows basically that choice to be in the hands of the plaintiff. The plaintiff makes the decision about whether they're filing their discrimination charge or not. So if they're interested in a settlement that includes confidentiality provisions, you can have that negotiation before filing a charge. And if you want to take that off the table, you can do it at any time by filing the charge, and then an NDA is not something an employer can insist on. So a lot of action by the states in this space. And there's one close to DC example. In 2019, for example, Virginia enacted legislation prohibiting requiring employees to sign confidentiality agreements as a condition of employment that reach sexual assault. There's also been a little bit of interesting legislation in the states around affirmative reporting by employers regarding sexual harassment complaints and settlements. So, for example, Maryland in 2018, I think, passed a law requiring employers, larger employers, to complete a survey from the Maryland Commission on Civil Rights on the number of settlements made by an employer after a sexual harassment allegation, and the number of times the employer has paid a settlement to resolve a sexual harassment allegation against the same employee. So trying to shine a light on if there is a problem that keeps happening with this employer, as well as reporting the number of sexual harassment settlements that included a confidentiality provision. And the aggregate number of responses from employers for each category will be posted on the Maryland Commission on Civil Rights website. So it's an interesting, innovative idea to try to bring some sunlight to these issues and to shift employer practices through the possibility of shame, as well as some exposure to the Maryland Commission on Civil Rights. We go to the next slide. States have also, as in the Be Heard in the Workplace Act bill, worked to do some structural shifts to how their anti-discrimination laws work. So extending the statute of limitations to file a charge, strengthening accountability for employers and harassers. So, for example, limiting public officials' ability to settle sexual harassment complaints using public funds, which is also a reform that actually did pass in federal law a couple years ago, making clear that if you, an elected official, harass somebody and then reach a settlement, that you're going to have to pay for that out of your own pocket rather than using taxpayer money to do it. Some states, a few states, have addressed overly restrictive liability standards, going to the severe pervasive type test to try to make clear that there is a wider range of harassment that's unacceptable in today's workplace than some courts have acknowledged. And yes, some states have also removed caps on damages to ensure that victims can be made whole if they go through if they overcome all the many hurdles to getting to court and succeeding, that you should have a remedy that actually addresses your full damages. And then one or two more areas of state law reform to flag. On the next slide, promotion of prevention. A lot of states have required anti-harassment training or anti-harassment training by certain employers. 11 states and New York City have either for the first time passed a training requirement or strengthened a training requirement. A few states have explored climate surveys. For example, Vermont enacted legislation giving their Human Rights Commission the power to require employers to undertake climate surveys, which are anonymous surveys that give employees the ability to tell their employer about hotspots, about issues, about things that an employer should know about and should be addressing. And there are also 7 states that have enacted measures to require or encourage employers to adopt anti-harassment policies. So, for example, New York required its Department of Labor to create a model sexual harassment prevention guide and prevention policy for employers, as well as requiring state contractors to provide their anti-harassment policy as part of the contract bid process. So it's a place where we continue to see state legislatures really interested in policy changes that have a lot of potential to shift the dynamics on the ground, and that's been really exciting.
You know, and I think what you've highlighted here is this idea of shining the light on these issues through legislation. By the law, and then the legislation that Maryland had also brought up. And I think that also speaks to really like this general public policy now of making sure you bring these issues up as they arise, and creating not only through legislation the right framework for businesses to be able to follow, and then also create buy-in. But also, I think from the perspective of how to make that general change, in addition to legislation, I think coupling it with this corporate governance perspective, where if you are looking to have top-down buy-in and looking at having, a key leadership position, for example, at the C-suite level, or at the board, for example, and at the law firm level for the executive management, and looking and creating some kind of governance structure, so that part of whether or not you are actually managing and exercising your fiduciary duties to be an executive for a company or a law firm even, is to assess whether or not your company is healthy in that workplace sense. And so I think that would be a good couple also in terms of this, this legislation effort, so that if you are a general counsel for an entity, for example, it would be great to start having these conversations on how do you incorporate these considerations into the corporate governance structure of your entity at the same time. So, with that being said, do you think that there are any other, future policy considerations that we might see coming down the pipeline, either from the legislation side of things, or maybe just from the general employers, that you think could probably pop up in the next, let's say, 5 years or so?
Well, I think one thing we're likely to, or we might well hear more about, that sort of speaks to some of the issues you just brought up, is public companies disclosing to shareholders information about harassment complaints and their responses to harassment complaints. There's another bill called the Empower Act that Kamala Harris is the lead on, that would require those public company disclosures, as well as providing for a confidential tip line to the EEOC and doing some reform of non-disclosure agreements. So depending on what happens in the election, it is certainly an issue where we might hear more of that model. And I also think that you're exactly right that this is a corporate governance issue, and one of the places where I think certainly nonprofits, but I suspect for-profit institutions have also been doing thinking, is making sure that their harassment policies, that their harassment training also reaches their board, their funders, the third parties who their employees have to work with, and to ensure that there are policies in place and reporting pathways available if you are being harassed or experiencing other sorts of discrimination at the hands of someone who is not your supervisor and not your coworker, but someone who you have to work with as a result of your job.
I'm going to interrupt briefly to give the CLE code for today's class. The code is WP84. That is W as in William, P as in Peter, 84, and once more, W as in William, P as in Peter, 84. Thank you.
And so as we, look into now, transition into the best practices portion, because Emily, you also, agreed that corporate governance is certainly an important issue. And now I know that a lot of the audience members will probably have a lot of questions, either in the chat box or in the Q&A section, down below, in terms of how do we then actually navigate the workplace itself. And it sounds like from everything that we've been hearing so far, we've discussed, is that the key takeaway is that organizations should establish some kind of infrastructure that provides the tools and the resources for intervention, reporting, investigation, some level of accountability. And I guess the big question is now is, what do we do next? What is the actual practical application and the practical interaction that we might have in the workplace? And so I'd like to kind of step through some of these most common questions that folks might have about navigating in the workplace now. So one of the questions that I often hear a lot is, well, what can my organization actually do to empower people to speak up, right? So there are really three main things that I have seen being fairly effective. One is that some organizations have installed some kind of bystander training. The second is being inclusive in meetings. And the third is leading by example. And in terms of bystander trainings, this really dives into organization-specific environments as well. Because if in instances, as we've seen in the statistics from NPR in 2018, a good nearly half of the workforce have seen or witnessed incidents of harassment in their workplace. And the question is oftentimes, what do I do to intervene? What do I do to make that situation never repeat itself again moving forward in the future? And so what organizations have also done is making sure that they actually create or engage a third party, for example, to engage in that dialogue, to find out what types of interactions are most common in their space, how best to engage in that interaction, and in instances where either the victim or the perpetrator is involved in the entire exchange, how a third party might be able to interact with them. And so, if you are a leader in that space, that maybe examining what types of bystander training could help to empower people and give them the right tools to engage and maybe de-escalate a situation has also been found to be very effective in terms of creating a safer environment. The second point, in terms of being inclusive in meetings, this is kind of like the low-hanging fruit I think anybody can really do, right? So if you are leading a meeting, if you're participating in a meeting, I think everybody has had that situation where you might have provided some kind of suggestion or an idea about whatever the topic of that meeting might be. And either it hasn't been acknowledged at the exact same time that you made that suggestion or that comment. Well, let's say fast forward maybe 10 or 15 minutes from now, another individual may have raised that same issue. And at that point, people are now saying, oh, yes, great idea. Absolutely. I think in those instances, what could be extremely helpful is to actually support, to go back and acknowledge the individual who first raised the issue. And by doing though, that actually does a couple of things, right? That it gives that person a sense of empowerment that their feelings or their comments have actually been heard, that they're being acknowledged in the workplace, and that in that space where it is a gathering of team members, they actually have a voice. And to cultivate that kind of culture and environment in even that small window of 30 minutes or a 1 hour meeting, that could also help them in terms of finding their voice later on and making them feel more empowered to raise the issue of harassment within the workplace. Because if they, for example, do experience that kind of scenario, they might actually turn to the people who assisted them during the meeting and who had their support and acknowledge them and encourage them to speak up in that instance. And I think that's a very low hanging fruit that people should start considering and maybe even, start exercising today. As soon as you finish this session, it's very low hanging fruit. It's very easy to enact. And I think the ultimate reward at the end of that and the end product of that is you'll find that more people are going to be empowered to speak up and raise issues. So that then everything that, Emily, you've shared about the legislation and maybe top-down approaches from the workplace itself and leadership and the corporate governance side of things will actually be fully applied and executed to the full extent of it. And then leading by example, if you're a leader, if you are a supervisor, make sure that you're actually encouraging the entire investigatory process and reporting process, and also, really living the policy that your company or your firm or your entity has actually put into place. So the other question that some folks have asked in the past is, how do I greet people? If you're a hugger, do I no longer hug? Am I now just shaking hands? Do I just nod? And I think ultimately it's a mixture of a couple of different things. One is having a sense of what your relationship is with that individual. If you have always been a hugger with that person, continue on with that kind of interaction. But I think the sense is, just being more aware of the interactions around you also, whether or not that's the first time you've met. There's that same continuity, I think, in how you would want to interact with people. Another question some folks have had is, how do you now give a compliment or criticism? Is it even possible to give a criticism to another individual because they're a woman or because they fall under some kind of, demographic, for example? And then ultimately, I think in those instances, if it's a compliment, if it's in the workplace, it would be helpful if you focus specifically on work issues or something that is tangible related to the actual work. So for example, if it is with regards to an attorney drafting a memo or drafting some kind of pleading, to provide compliments or criticisms based on that subject matter itself, so that you're not also putting yourself at a position where it could be called into question later, where there's some subjectivity involved as well. And lastly, can I still socialize with my colleagues? The answer is yes. I think that is still something that, despite the Me Too movements shining the light on a lot of these issues, is that you can still interact with your colleagues. The only thing that's being asked of you is that you just have a better sense of your interaction with them. For example, if you are in a team of 5 and you have a happy hour with your team and maybe 4 of the 5 are in attendance, making sure to have that sense of awareness with your team and making sure that they're also equally included. So then that there's no sense of bias potentially, and especially if there was maybe an issue of a claim being filed earlier, just having that opportunity to just having a better EQ or emotional IQ, I guess, lack for a better sense of it, in terms of interacting with their colleagues. So, that being said, is that this Me Too movement and what we've heard so far is that you can still certainly engage with all of these things with now, just a heightened consideration of what kind of effect that interaction might have with the rest of your colleagues and also your entities. So Emily, in light of maybe what you've come across, are there any other best practices you think that would be helpful to share with our audience today, that whether or not they're general counsel or just, other members of their organization, that you think would be extremely effective and efficient in terms of advancing this effort?
Yeah, I think you've done a great job at identifying sort of some of the things we can do in our own work lives, as employees. I think for those who are helping to set policy for an organization, that one of the things that's really important to do is to create multiple avenues for reporting, to make sure that there's not just one door you go through, one person you have to talk to take into account some people are more comfortable writing it down. Some people are more comfortable having a face-to-face conversation. And you don't want one person at the organization to be the person who gets all the complaints, because what if that person is best friends with the harasser or is the harasser herself? So multiple avenues for reporting is great. Setting tone at the top is really critical. Employees can hear the difference between a going through the motions and some real commitment to equity and safety and dignity in the workplace. And so for leaders to speak to these issues and speak to them often, speak to them regularly, speak to them as core business issues is really important. Evaluating outcomes when you do these trainings, to try to put some method in place, whether it's regular climate surveys, whether it's some tracking of complaints, though more complaints isn't necessarily bad. It could mean that people are comfortable now coming forward when they weren't before. But let's do some work, not just to do the training, but to try to get responses from the folks who are trained about whether this changed their perceptions meaningfully, whether they feel more comfortable coming forward with issues, evaluate your outcomes, and hold managers accountable for culture change work. This can be a thing that is with part of the performance evaluation, part of the compensation review. How did you as a manager help forward these goals? It's really important for organizations to prioritize anti-retaliation efforts. Retaliation is a huge problem. And so that's another place where, among other things, tone at the top, training of managers, and some real follow-up with supervisors to make sure that retaliation isn't happening, that it's not being tolerated. It's a really critical piece of the puzzle. And the last thing I will say is I think it's important for organizations to recognize that diversity and inclusion work is anti-harassment work. It's not like there's the anti-harassment piece, which is the sexual harassment training, and then there's all the work that we're doing to create more diverse pipelines and ensure that we have more women and people of color, and other underrepresented groups in leadership, that these things work together. And part of shifting a culture is diversifying who holds power in the workplace. Certainly possible for a toxic workplace to exist with a woman in charge, but we know that workplaces that are more male-dominated, that are more homogeneous, are also more likely to be hostile and harassing to the folks in those workplaces who don't look like that. So situating anti-harassment work within a broader commitment to diversity and equity is also really important.
Gosh, well, thank you so much, Emily. I think everything that we've discussed today, I'm hoping is some very, very great takeaways for our audience today. That actually brings up to the conclusion of our session. So thank you very, very much to everyone for joining us. And we hope that you've come away with a better understanding now of how best to navigate the workplace.
Oh, and we can put up the last PowerPoint slide, which has some resources, almost all of which are on the National Women's Law Center's website. And we can hopefully also share them in the materials so that folks have them, but I hope it's useful for folks who want to dig in deeper on any of these questions.
Absolutely. And please feel free to drop us some questions, and so now we can turn to them. Thanks, guys. Thanks, everyone.
Thank you.
On behalf of the DC Bar and the 2020 Conference Planning Committee, I'd like to thank our speakers for taking the time out of their busy schedules to present on these important topics. As a reminder, please be on the lookout for the email from the CLE staff to submit your codes for credit, as well as to complete the class evaluation. Feel free to send us an email at cle@dcbar.org if you need any help. We look forward to seeing you at future programs, and thank you.